Good morning. This is an open meeting of the United States Securities and Exchange Commission on April 27, 2011. Today we'll consider two items stemming from the Dodd-Frank Wall Street Reform and Consumer Protection Act. First, we'll consider proposing new rules and interpretive guidance regarding the definitions of swaps. And second, we'll consider proposing new rules that would further remove from our rules references to credit ratings. The first set of proposed rules and interpretive guidance we're considering relate to the definitions of the terms swap, security-based swap, and security-based swap agreement. The proposal stems from Title VII of the Dodd-Frank Act, which established a comprehensive framework for regulating the over-the-counter swaps markets. Under the new law, regulatory authority over this market is divided between the SEC and the CFTC, with the SEC regulating those products deemed to be security-based swaps and the CFTC regulating all other swaps. Both the SEC and CFTC jointly regulate mixed swaps. Although the new law contains broad definitions for those terms, it directed us to define them further. And it has directed us to develop these definitions jointly with the CFTC, which is also voting on these proposed rules today. The joint proposed rules and interpretive guidance would clarify certain transactions that are outside the scope of the definitions of swap and security-based swap, such as insurance, contracts, and certain commercial and consumer transactions. The joint proposed rules and interpretive guidance also would clarify certain transactions that are within the scope of the definitions of the term swap and security-based swap, such as certain specified products and transactions based on interest rates, other monetary rates, and yields. In addition, today's joint proposed rules and interpretive guidance would clarify the applicability of the narrow-based security index definition to certain products, including index credit default swaps, the scope of regulation of mixed swaps, and the books and records requirements relating to security-based swap agreements. The definitions we propose today balance several policy and legal issues in a way I believe is practical, takes into account the specific nature of derivatives contracts, and is consistent with existing securities regulations. The proposal before us seeks to provide guidance in rules and interpretations by using clear and objective criteria that should clarify whether a particular instrument is a swap regulated by the CFTC, a security-based swap regulated by the SEC, or a mixed swap regulated by both agencies. We look forward to public comment on today's proposed rules and interpretive guidance. As you know, we formally reopened the comment period on Regulation MC and are still welcoming comments on other proposed rulemakings under Title VII, even if the comment periods have already closed. And yet, we have several rules still to propose under Title VII. When we have completed all rulemaking proposals, we will consider what further opportunity for public comment would be appropriate. Before I ask Robert Cook, Director of the Division of Trading and Markets, to discuss the proposed rules, I'd like to express my gratitude to the CFTC staff, commissioners, and Chairman Gensler for their tireless efforts in crafting these proposed rules along with our terrific team at the SEC. Undertaking a joint rulemaking of this magnitude is a challenge, but the CFTC has been an excellent partner throughout the process. I also want to thank Robert as well as Brian Bussey, Greg Berman, Matt Dagler, Christy March, Leah Drennan, and Jack Habert from the Division of Trading and Markets, Amy Starr, Tamara Brightwell, and Michael Riedich from the Division of Corporation Finance for their hard work on this rulemaking. Thanks as well to David Blass, Paula Jensen, Meredith Mitchell, and Cynthia Ginsburg from the Office of the General Counsel, Lisa Watson and Jeffrey Cohen from the Office of the Chief Accountant, and Jennifer Marietta Westberg, Eric Carr, Adam Yance from the Division of Risk, Strategy, and Financial Innovation. And finally, I want to thank the commissioners and all of our counsels for their work and comments on the proposed rules. And I will now turn the meeting over to Robert Cook to hear more about the division's recommendations.